everyone. I can see there's still a few people coming through, but we'll get started. You are all very welcome to today's webinar on navigating the ESG disclosure landscape. My name's Helen Bowdra and I'm a partner at Denton's. I'm based in London and I have the great privilege of leading our ESG practice here. So today's webinar is the fourth in our global series, and we are focusing on bringing you practical insights on some of the most topical ESG issues facing you and your in-house teams. So to date, we have looked at ESG and climate-related litigation. We've also looked at ESG in supply and value chains and financing sustainability or impact. So if you missed any of those previous sessions and you would like to get a copy of the recording, please just drop a note to esgprogram@dentons.com, and we'll be very happy to send that across to you. So with that context in mind, today's session is really all about you. We are really keen for all of you to get the most value out of it in terms of the practical takeaways. And I would encourage you to use the chat function to let us know of any questions that occur to you as we go through today's session as well. And now moving to our panel, ESG is a global topic, and I'm really delighted that we have a really international team for you here today. We've got Julia File, who's a partner in the Denton's Frankfurt office, Katie McCaskill joining us from Glasgow, Evan Janssens from New York, and Amy Morin here with me in London. And you'll be hearing from all of them as we go through today's session. We've structured the session into three core areas. So just looking at the agenda, I'll start off with an update on the key risks and trends that we're seeing emerge from the global regulatory outlook. Amy is going to talk us through the CSRD before we dive into some of the practical challenges we are seeing clients respond to and preparing for compliance. Evan's going to add some updates on what's happening in the US, particularly with regard to the SEC climate change disclosure requirements. And then we're going to hand over to Katie, who will talk us through the supply chain issues, particularly focusing on CSDDD and the deforestation regulation. We will hopefully have some time for questions at the end, so please feel free to drop those into the chat function as you think of them, and we'll try and pick them up at the end. Or if we run out of time, or if they're very difficult, then we may need to get back to you afterwards, but we'll try and pick up as many as we can today. So moving on to the topic of today, which is ESG disclosures and particularly the global regulatory change. We saw from the response rate when we sent out the invitation to this webinar that this was a very, very important topic for all of you, because we saw a really high response rate to this particular webinar. And I know from speaking to clients every day that this, these disclosures are something that you are really grappling with, and that are, from a practical perspective, posing a lot of challenges to companies in Europe and globally as well. And I'll just talk about some of the key trends we're seeing in this space. So first of all, I'd say we're moving into a world where what were previously voluntary commitments are now becoming mandatory. So this isn't about CSR anymore. This is about you having a series of quite extensive annual disclosure obligations on a range of ESG and sustainability topics. So where previously you might have been putting out a sustainability report, where you had quite a lot of autonomy and control as to what that report contained and what it didn't contain, we are now moving into the world where the legislation is much more prescriptive about what needs to be in that. And we're also seeing some frameworks that started off as it were being voluntary or some form of soft law becoming mandatory. So we've seen that with the OECD guidelines for businesses, particularly in relation to responsible business conduct. They were really designed as a voluntary tool for companies. They were binding on countries, but not sort of individually on the companies. They are now being used as the framework for some national legislation in Norway, for example, and in Germany as well. And we're seeing some of that OECD framework come through in the CSDDD as well. Another topic is the standardization of reporting. So we've put up some of the acronyms, and I'm going to apologize in advance. There's a lot of acronyms in this space, but some of these you might be familiar with. TCFD on climate-related financial disclosures, the ISSB, the GRI, the Global Reporting Initiative. CDP, and SASB as well. And so again, we are seeing some, I suppose, coalescence around particular standards. TCFD is now very widely used. And I think under the CSRD, which we'll be talking about later, the ESRS are going to be a really important standard as well. Hopefully that standardization is helpful for business, but I would say that on something like the CDP, which Denton's we disclose under, I know, having looked at our recent disclosures, and we're not a particularly complex business from an environmental perspective, but I know that standard has become much more onerous in recent years, and so something that was a bit more straightforward to do is now much more complex. And the other topic that we're seeing really is this changing perception of ESG risk. So when you're making these disclosures, you do need to have an eye to who's the audience for them, who's reading them. It will be your shareholders, your investors, perhaps your customers, your competitors, and of course also perhaps your litigation counterparties as well, and NGOs who might be looking to launch a campaign as well. So once that data's out there, it's out there for a variety of uses. So it's worth having that in mind as well. And so that leads us on nicely to what is currently probably one of the most extensive disclosure regimes in the world, which is the CSRD. And I'm going to hand over to Katie to talk us through how that's working in practice. Over to you, Katie.
Thanks, Helen. So as Helen's just mentioned, I'm going to be diving in a bit more detail into the CSRD, which has introduced a comprehensive sustainability framework across the EU. I'm just going to give a brief overview of what that regime is, what it requires, what some of the key points are to be aware of in terms of preparing for reporting, and then we'll move on as well to discuss some of the more practical implications of that. The CSRD aims to ensure that both investors and also wider business stakeholders have access to the information that they need to assess both the financial effects of climate change and other sustainability matters on the business, but also the business's impacts on people and the environment. So broadly, what it requires is for in-scope businesses to publish an annual sustainability statement as part of their corporate reporting, in a specified format with quite detailed disclosures about the sustainability matters that are material for that business. And the detail of those disclosure requirements is set out in the European Sustainability Reporting Standards, or the ESRS. The regime is currently being phased in, so we're expecting to see the first entities reporting next year in 2025 in respect of their 2024 financial year. And those are large listed EU companies. And that phase-in then continues over the next few years. So from the 2025 financial year, we see other large EU entities and groups coming into scope. From 2026, listed EU SMEs. And then from 2028, the regime extends to cover non-EU companies with significant business in the EU. The details of the thresholds for that requirement are set out on the slide. It requires a subsidiary or a branch in the EU and the satisfaction of certain turnover thresholds as well. When those non-EU companies come into scope, they're required to report at the level of their ultimate parent in respect of their global operations and not just their EU business. The scope thresholds here are quite detailed, so large groups might need to assess across their various entities where the turnover and employee thresholds apply and which entities are in scope. And of course, for global businesses, it's likely to be the case that EU subsidiaries will be in scope first in respect of EU business, and then it might extend to global operations if those thresholds are satisfied in 2028. The CSRD is quite a complex and detailed reporting regime, and it's also quite broad in scope. So I'm just going to use the next few minutes to run through a few of the important concepts that you need to be aware of when you're preparing for reporting under the CSRD and implementing these requirements internally. I think the first one that's important to talk about is double materiality. When you're preparing for CSRD reporting, first step is to carry out a materiality assessment to identify the sustainability topics that are material to your business that you'll be required to disclose on under the CSRD in accordance with the ESRS requirements. And the CSRD requires companies to do that on a double materiality basis. That means that companies need to take into account both the material financial effects of sustainability matters on their business, so material risks and opportunities, but also that they need to consider the material impacts that that business has on people in the environment related to those sustainability topics. And that impact materiality threshold might be familiar to businesses reporting in line with certain voluntary frameworks, but may also be new to some entities reporting under the CSRD for the first time. The CSRD doesn't prescribe a methodology or threshold to the materiality assessment, but there are some general requirements in the ESRS on the approach and practice to consider, and there's also detailed guidance available to help businesses with that process. The other important factors to consider when implementing CSRD requirements are the scope of the regime. Firstly, it covers a broad range of sustainability matters. These are set out, listed in the ESRS. It covers topics including climate, biodiversity, nature and environment, workers, human rights, communities, and corporate governance topics. So it's very broad in scope in terms of the subject matter it covers across a business. I think the second point on scope and the extent of the regime is that when businesses are assessing their material sustainability matters and preparing their disclosures, they're required to take into account sustainability matters that are material not only due to their own operations and activities, but also those that they're connected to as a result of their upstream and downstream value chains. So that might include, for example, the raw materials that they use, their direct or indirect suppliers, contractors, service providers, but also the products that that company produces, the services it provides, and the end users of those. So again, that's quite broad in scope, and it means that the assessing materiality and preparing for reporting can require data collection from quite a broad range of sources. The other important thing you need to understand is the disclosure requirements that apply under the European Sustainability Reporting Standards. The ESRS are extensive and require quite detailed and specific information to be disclosed on the sustainability matters that you've identified as material for the business. Exactly what's required varies from topic to topic, so it's quite important to go through those in detail and consider exactly what's needed. But to give a sense, broadly, what's required is information on the material sustainability impacts, risks, and opportunities that have been identified, any policies the business has in place, actions it's taken, or targets set related to those, as well as the disclosure of specified metrics related to performance. The CSRD is broadly a disclosure regime, so it doesn't necessarily mean that actions need to be taken or targets need to be set, but it does generally require businesses to report on what they're already doing. And we're also expecting to see additional ESRS published in due course, setting sector-specific disclosure requirements and the disclosure requirements for SMEs and non-EU entities when those come into scope of the CSRD in due course. So it's important to look out for those to make sure you can identify the disclosure requirements that apply. And I think the final key point I wanted to flag in terms of preparing for CSRD reporting is that the sustainability statement is required to be subjected to independent assurance on a limited assurance basis prior to publication. It's just important to be aware of that and factor it into your planning internally for CSRD reporting and for your timings of that. So I think that's all I wanted to cover in terms of an overview of how that regime works. And I think I'm now going to hand back to Helen for the poll.
Thanks, Amy. And I'm so sorry I introduced you as Katie at the start of that. It is, of course, Amy. But yes, we're going to run a small poll now just to see how many of you are currently involved in CSRD and what your sort of direct experience of that is. So over to you, Nee, for that.
Thanks, Helen. So as Helen said at the outset, we're always really keen to get your views and input on this topic. So you should see two questions on your screen in poll format. You may have to scroll down to find the second question. The first question you'll see is whether or not your company is required to disclose under CSRD. And we'd love an indication from everyone attending today as to whether or not you're currently required to disclose under CSRD. The second question then, I suppose, delves a little bit deeper around what you see as the most challenging aspect of preparing for compliance. Is it identifying the entities that need to comply with CSRD? Is it, as Amy mentioned, carrying out a double materiality assessment? Maybe it's managing all those internal stakeholders as you go about collecting data. Is it the gathering of the relevant data itself? Perhaps it's external assurance, or maybe it's something else entirely. And if it is, please drop us a note in the chat. We'd love to hear what exactly is your view on the biggest challenge. So it's lovely to see so many people getting involved. So we're past the 50% mark at this point. We'll just give everyone a last chance to indicate their views on this one. Let's go 5, 4, 3, 2, 1. I can see lots of final votes coming in. So Helen, let's close the poll and we're going to share the results with everyone so that you can get a sense of the views and the impact on everyone attending here today.
Thanks, Niamh. Okay, so in terms of who's required to, so yes, 42%, no, 28%, lucky you, 28%, and I don't know, 30%. I think that's quite interesting actually, because the thresholds for compliance with CSRD are not that high. You know, if you're a business of any sort of reasonable size operating in Europe, whether that's through a branch or a subsidiary, you could well be in scope for this. And actually, that it's really important to check that at this point. You know, for those larger businesses, as Amy said, we are expecting first reports in 2025 based on 2024 data. So if you don't know, it's worth maybe checking internally whether that assessment has been done for your business to see whether any compliance is needed. And then moving on to what's the most challenging aspect, and it just looks like so it's a bit of an interesting split. So 44% saying gathering the relevant data, and that certainly accords with, I think, what we're hearing, that this is a very, very extensive exercise involving lots of different parts of the company that may not be used to providing data in this format. And then managing the internal stakeholders, again, I think that is complex, you know, across different regions, perhaps different budget holders as well. And that's something we are seeing, that this is not, you know, this can't be done just by your sustainability team alone. You know, it will need input from lots of other teams as well. I am really interested to see that only 15% have found that carrying out a double materiality assessment was the most challenging part, because that, you know, that is generally we're finding quite a lift. So maybe it's that people haven't had that joy yet. And then identifying which entities need to comply. Again, you know, that can be quite a complex exercise depending on how your structure looks in Europe. So thank you, Niamh. We'll close out the poll and we'll just move now to a discussion really on CSRD and on some of the topics that we are seeing coming up quite a lot that may also be relevant for you. So Amy, if I can come to you first, maybe on the internal stakeholders, when you're working with clients on their CSRD program, what are the stakeholders who typically would need to be involved in this project?
Yeah, so we often see it being led by internal corporate sustainability officers or sustainability teams, basically, because obviously it's primarily a sustainability disclosure regime. But given what I've said about the broad scope of the regime in terms of subject matter and also the extent of the disclosure requirements, it actually can require quite a lot of internal resource and quite a lot of collaboration across the business. So we typically also see involvement from the finance teams and the other teams that are involved in corporate reporting, because of course CSRD disclosures feed into that process. From legal on compliance, also from, you know, areas of the business such as HR in relation to some of the worker impacts, potentially from the procurement teams, given there might be a need to get information from external stakeholders as well.
Thanks, Amy. And as we said, we're expecting the first reports in 2025. Julia, in Germany, there'll be some big German businesses that are in scope in that first wave of reporting. What are you sort of expecting to see in those reports, and what are you hearing from clients in Germany?
Well, the overall feeling is people are kind of half prepared, half not. After all, we already have in Germany the Supply Chain Due Diligence Act. So many of the things that are relevant for the reporting, companies, businesses should already be aware of under the Supply Chain Due Diligence Act. So some of the preparation has already been done. Apart from that, we see probably the same difficulties as everywhere else. Issues mainly revolve around who is responsible, who takes the lead in reporting. We've seen quite a number of cases where it wasn't really clear, or where responsibilities across the board or in the management team were shared. So that has to be sorted out before. And then if the information or some of the information is usually found within the responsibility of one kind of section of the company, while reporting obligations are with another section. So getting all the required information together can prove quite a challenge. In particular, if relevant reporting lines, relevant processes and procedures aren't there yet. And then, of course, the question is, how much do the legal teams need to be involved in this? Do you run this under legal? Do you run this under compliance? Do you run this under corporate sustainability? Or shouldn't this be an issue that's run under finance, simply because of the fact that all the other reporting tasks are also done by the financing team? So this is all challenges that need to be overcome. And then what we do see is still, in some companies, is still kind of a cultural challenge, because traditionally CSR, ESG, that was seen as more of a soft topic. Companies who want to do good for the world. So often you find very strong interest in these topics in the marketing departments, or people taking care of marketing, and all of a sudden the finance people, finance departments come along. So you have something that usually considers themselves and their task as rather soft and being approached, how to make things more beautiful. And all of a sudden you get the financing guys in there who say numbers, this needs to be hard, this needs to be double checked. And we even need to get outside assurance. So those are also some cultural, I wouldn't want to call it cultural clashes, because that's not true. But all of a sudden you see different cultures from different departments, different areas of a company, of a business, that all of a sudden need to work together in a new sort of way.
Yeah, and that's interesting, the point around, companies having different cultures depending on perhaps where they're headquartered. Are you seeing sort of different approaches depending on whether it's a North American company with subsidiaries in Europe versus a German or French company, for example?
Yeah, but yes, of course, but that's not so much due to the fact that we're talking about ESG. That's due to the fact that usually companies from those very different parts of the world, who are also culturally very different and have very different corporate cultures, are run quite differently.
Yeah.
So, as a German, we usually talk about our two-tiered management structure with the very strong, very clearly defined tasks of the supervisory board and the managing board. And that's usually something that's rather hard to make our American clients, American friends, understand how that's run. And then you get the French with the CDG persons in. It's all, so the cultural differences there, depending on the geographic area, that's nothing particular to ESG. That's rather more to really completely different corporate cultures.
Yeah, thank you. And on the risks associated with CSRD reporting, it's not voluntary. If you're in scope for it, it is mandatory. Amy, I wonder if you can just talk a bit about some of the risks associated with these disclosures, though.
Yes, of course. So I think firstly, these reports could potentially be reviewed by quite a wide range of stakeholders. I think one of the key risks associated with CSRD reporting, as there may be with voluntary sustainability reporting, is reputational. These may be reviewed by investors, but also by civil society, consumers, and other stakeholders of the business. There's also obviously compliance risks that will depend on how the CSRD is incorporated into local legal regimes. Often it forms part of the corporate reporting structure, so there will be duties and obligations related to the level of reporting that's being done under CSRD as well.
Yeah, thank you. And definitely that wider audience of bearing in mind who's going to be reading these. I think there'll be a very rich source of information, the CSRD disclosures. Well, thank you. We'll close out that discussion session now, and we'll hand over to Evan to kindly take us through what's happening in the US around climate disclosures. Over to you, Evan.
Thanks, Ellen. So certainly, a comprehensive account of the disclosure requirements under the SEC's final rules is obviously beyond the scope of our limited time. So I'll highlight the takeaways and tell you what you should be mindful of right now. How did we get here? In early April this year, less than a month after their adoption, the SEC decided to put on hold its climate-related disclosure rules, pending the judicial review of several petitions that were consolidated in the United States Court of Appeals for the Eighth Circuit. And this April SEC order referred to a lot of things, referred to the review petitions that were filed in court after the March rules went into effect, when they were adopted. And this order referred to the judicial order that had consolidated these petitions in the Eighth Circuit, as well as the lifting of a stay in the Fifth Circuit. So as you can kind of tell, there's a lot going on. There's been a lot of litigation. It's cast a cloud of uncertainty over how registrants view their obligations in virtue of the pendency of the claims as to their constitutionality or their validness. So one thing that's crystal clear is that the Commission has made it plentifully obvious it's not revising its position that the rules are in conformance with relevant law. They're going to defend their validity intensely. Really, their decision to pause the implementation of the rules stems from the procedural intricacies of these proceedings. So that's the background, essentially. Right, regulatory disorderliness abounds as we're just trying to sort this all out. So, but these rules will probably be here before we know it, and why is that? So this is self-evident, but remember the final rules consist of duties of disclosure, right? The rules do not tell you what to do. They do not tell you how to operate your business in the least. So what they do is that they require that issuers of securities, they use a climate-based target or goal, disclose certain information in their registration statements, their annual reports about, among other things, climate-related risks that have materially impacted or reasonably likely to materially impact their business. And in addition, an issuer has to disclose any progress made toward those goals or targets and how that's accomplished. But these rules do not mandate in any way how the issuers are supposed to set or determine these targets or goals. So in a similar vein, if an issuer, and I quote, has adopted or uses transition plans, scenario analysis, or internal carbon prices to manage or assess the impact of material climate-related and transition risks, then it's also required to disclose other information about those tools, but they don't require you to select these tools, right? So look, in my view, the likelihood of success of these claims alleging unconstitutionality in the US setting is low. As asserted in the SEC's brief, the final rules are modified based on the agency's consideration of the proposed rulemaking, and the disclosures were made, and I quote, more useful to investors and less costly, pursuant to the SEC's well-established authority to require this disclosure of information. The SEC has argued many times that the disclosures are meant to address existing inadequacies in the current regulatory disclosure framework. So ultimately, these rules are about disclosure, familiar, fact-specific application of the materiality threshold, nothing more, nothing less. So it's just difficult to see how these rules mandating periodic reporting of the targets and goals, and in certain instances, a company's greenhouse gas emissions, how they're arbitrary, capricious under relevant law, how this would exceed the bounds of the SEC statutory authority. Now, I should note, it is true that with the US Supreme Court's recent decision to overrule the so-called Chevron doctrine, which, as you may know, had compelled court deference to reasonable federal agency interpretations of ambiguous statutory laws that they're charged with enforcing or implementing. The end of Chevron deference means the expansion of individual judges in the domestic lawmaking process in this respect. So what that means is that it's possible that the Eighth Circuit here will adjudicate the legal issue in a way that is in contradiction to historical SEC practice or similar informal rulemaking, but there's just ample reason to believe that these rules are going to be upheld in their current manifestation or something very similar. Again, the SEC has meticulously considered more than 24,000 comments, has incorporated alternative ideas into the final rules, just as you see, as the SEC typically does, balancing the compliance costs with the anticipated regulatory benefits. Most notably, the SEC reduced compliance expense for smaller companies relating to certain greenhouse gas emission disclosure. You know, the commission thoroughly evaluated the potential unintended consequences of so-called Scope 3 greenhouse gas emissions, and had, in the final rules, declined to require issuers to reveal those emissions, which is a huge change. And that's a huge win for agricultural groups, particularly small farms. So, but keep in mind, many companies may still need to lay out the climate impact of their suppliers under a California state disclosure rule, which was approved last year, I believe. So there are duties on thousands of companies with California operations in the meanwhile, which beget their own challenges. And you know, we have a market-leading state attorneys general group, which advises on state law developments in all respects. So I highly encourage you to potentially seek informed counsel from us with regard to those issues. But just back to the point, in addition to getting rid, scrapping the Scope 3 greenhouse gas emissions requirement, the Commission limited Scope 1 and Scope 2 disclosure for large accelerated filers and accelerated filers, and only if such emissions are deemed material, including an independent attestation report. The Commission has eliminated disclosure regarding directors' climate-related expertise. So you get it. In summary, the SEC rules have been pared down from their original formulation 2 years ago. You know, the litigation process will almost surely delay the effective date of the rules, but registrants should really continue their ongoing compliance assessment efforts to prepare for their effectiveness. Lastly, I should note that the SEC has stressed that in its April order that the existing disclosure guidelines around climate remains true. Specifically, the SEC is expected to continue to review and comment on disclosures based on the Commission's climate-related disclosure guidance back in 2010 and a sample comment letter issued in 2021. So, and this is a crucial point, finally, most of the large US-based issuers that are regulated by the SEC, you're going to have to comply with the CSRD anyway, given your operations in the EU. So if this is you, you're going to have to be ready anyway. So CSRD compliance efforts should make the SEC rules framework less scary or intimidating in due course. So So yeah, thank you for listening. Certainly don't hesitate to reach out with any questions, whether me or your trusted dentist advisor relating to the SEC rules. They're multifaceted. They contain some tedious stuff. So my remarks are necessarily broad and informational. So I believe I'll turn to Katie now.
Thanks, Evan. Over to you, Katie.
Thank you. So this afternoon, I'm going to be talking briefly about the impact of ESG issues on supply chains. So if we just move on here to, so we're going to have a look at drivers for compliance. So as we've already touched upon, ESG has moved quite rapidly onto the agenda of large corporations who have moved towards a focus on responsible sourcing and good governance. So if we look at some of the key drivers of this can range from the points we see here. So emerging laws on ESG supply chain due diligence, a general kind of commitment to ESG related issues. There may also be directors' duties that require compliance. And then also the impact on brand and reputation. And I think the most important one is that in general, as Helen touched upon earlier, we are seeing a move from ESG being a nice to have, and instead it's a need to have as guidance becomes mandatory through legislation. And there's also been a significant move towards responding to climate change. And I think consumer choice and investor activism in this area and kind of increased levels of scrutiny, as well as social media have a role to play in this, just with customers and consumers able to be vocal about what it is that they want the companies that they invest in and use to be doing and be seen to be doing. So if we look at the way these elements come together and create an impact on supply chains, I would say that there's the kind of environmental impact that we'd be talking about today, and then there's also the human impact. So that would be things like modern slavery and human rights, which of course CSRD kind of touches on briefly as well. But then we've got the environmental issues, so things like climate change, emissions and waste. Now, we've seen a raft of ESG related legislation in recent years, and for this afternoon's purposes, I will be focusing on the Corporate Sustainability Due Diligence Directive, which is the CSDDD or the CS3D, and then we're going to move on to briefly talk about the EU's deforestation regulation. So the CSDDD came into force in July 2024. And it requires in-scope companies to conduct due diligence on and take responsibility for human rights abuses and environmental harm throughout their global value chains. So member states have 2 years to transpose this into national law. And as with CSRD, it applies on a phased-in basis, with the largest companies coming into scope first, and those deadlines applying from 2027 onwards. So in respect of the main obligations of CSDDD, they are particularly onerous. So it requires in-scope companies to identify and where necessary, prevent and mitigate and remediate potential and actual adverse human rights and environmental impacts whilst engaging in stakeholder consultation throughout. Companies require to refresh their mandatory human rights statements and due diligence assessments every 12 months. And where they're not already required to report on their processes under the CSRD, they will be required to publish an annual statement on their due diligence processes. So in that respect, the CSDDD and the CSRD are aligned, and there's not a requirement for double reporting, you'll be glad to hear. But most importantly, there is a requirement to actually integrate systems within your business's strategies and practices and your risk management system. So there is an active obligation to actually implement systems and also then report on them. There's also the obligation to adopt and put into effect a climate transition plan, which aims to ensure through best efforts that your business model and your strategy of your company align with the Paris Agreement. And that has to contain certain targets that are time specific and the actions that you have planned for obtaining and reaching those targets, as well as how you intend to fund and quantify how you're doing that. And there also has to be, crucially, a description of the role of your company management in connection with that plan and how you plan to achieve that. And I think that's an important point that comes back to what Yulia mentioned earlier, and that is the real requirement for cross-company buy-in. This has to go all the way to board level, but you also need to make sure that you have you've been getting input from the right teams. It's not just a case of engaging with your ESG or CSR departments. There has to be cross-company buy-in from finance and legal and HR, and that's certainly something that's come up a lot when we've been talking to clients about this. There can't really be one person in the business that's dealing with this because there are so many issues that it covers. So as I've mentioned, CSDDD requires measures to be put in place and systems integrated within your organisation, and it does require a report to be published on those measures. Now, the reporting obligation does fall after the obligation for measures to be put in place. But I think it's worth noting that given that this is quite an onerous regime, under CSDDD, companies aren't expected to guarantee that adverse impacts will not occur, nor that they will always be presented, but you are expected to take appropriate measures and show how those measures are capable of achieving your due diligence objectives. So those could include things such as developing and implementing a prevention action plan for adverse impacts, seeking contractual assurances from your supply chain, and making sure you've got measures to verify compliance, and having to adjust your operational practices where necessary and where you've identified that there are issues. So as we've mentioned, there's a phased-in approach to compliance, with the largest companies being required to comply from July 2027, and that applies to the largest companies. Now, just a quick mention in terms of who it actually applies to. I think it's really important to note that it isn't just EU companies. It does apply to companies that are out with the EU in certain circumstances. So, for example, where they generate a certain amount of turnover within the EU, or they are the ultimate parent company of subsidiaries within the EU. So it does have the potential to impact a lot of companies across the world. And I think just a final point on CSDDD, the aims of CSDDD and CSRD are quite similar. So both look to ensure transparency in the supply chain, but I think the kind of crucial difference is that CSDDD requires companies to actually take steps towards environmental and social responsibility by implementing systems within their processes, while the CSRD ensures that companies are actually transparent about what it is that they're doing. So I think now if we turn to the deforestation regulation, which is a hot topic at the moment. So deforestation is now the second leading cause of climate change globally, after burning fossil fuels, and it's responsible for around 11% of all greenhouse gas emissions. So in the last 60 years, more than half of all tropical forests worldwide have been destroyed, which has a knock-on effect on biodiversity and rare species. So the EUDR, the EU Deforestation Regulation, came into force in June 2023, and it was designed to promote the consumption of deforestation-free products and thereby reduce the impact of the EU consumer market on global deforestation. So it aims to achieve this by requiring operators and traders, so both of which have a definition under the regulation, from placing certain commodities which pose a risk to deforestation on the EU market. So they're required to carry out due diligence so that they can demonstrate that their products do not originate from recently deforested land and therefore haven't contributed to forest degradation. So the EUDR prohibits the placing on the market or the making available of certain commodities unless they are deforestation free. So those specific commodities are palm oil, soya, wood, cocoa, coffee, cattle and rubber, which are widely recognised as some of the key drivers of deforestation globally. And Annex 1 of the regulation lists the relevant products that are derived from those commodities, so products that contain or have been fed with or made using those relevant commodities. So as a whole, the regulation introduces a prohibition on the defined commodities being placed on the market unless they can be said to be deforestation free. They've been produced according to the relevant legislation of the country of production, in respect of various rights. So that could be anything from human rights to modern slavery. They're covered by a due diligence statement as well. So just to touch briefly on what we mean by operators and traders. So the obligations for operators and traders are different. An operator is any natural or legal person who, in the course of a commercial activity, places a relevant product on the market or exports them, whereas a trader is any person within the supply chain, other than the operator, who makes a relevant product available on the market. And there are different obligations. So where you have a trader who's a small or medium enterprise, the obligations are much less in terms of due diligence. But where you have a large trader, so a non-SME trader, they have quite high obligations, which are the same for operators as well. So that would involve undertaking specific due diligence when placing relevant commodities or products on the market. So that involves things like collecting specific due diligence information, assessing that, risk assessing that information, and applying kind of risk mitigation strategies. And that is all to comply with what are known as the Article 3 requirements, to ensure that products are deforestation free. Now, topically, the EUDR was originally set to apply from the 30th of December 2024. However, earlier this month, the EU Commission proposed an extension of a year to the effective date of the regulation. However, that does still require to be approved by the Parliament and Council, so it's not yet set in stone, but it certainly looks like there is going to be a 12-month extension currently. Now, when this was proposed, there was also additional documents that were published, and that includes updated guidance and FAQs. Again, those are all still subject to approval from the Parliament. But I think the key point to note here is that these all come on the back of extensive stakeholder engagement and consultation, as well as international dialogue regarding the complexities or the perceived complexities of the regulation. And there's been a lot of discussion around the uncertainty of the feasibility of the original planned compliance date of later this year. So if that extension is approved, which is, as I say, is looking quite likely, then there will be a 12-month reprieve, I suppose, depending which way you look at it, in terms of when compliance. So it will be looking like 30th of December 2025 for the largest companies, and then 30th of June 2026 for micro and small enterprises. Now, I feel like that was quite a raft of information, so we'll maybe pause now and move on to our poll.
Thanks, Katie. And that extension of the deadline, is sort of hot off the press. So we'll keep you updated on that as well. So I'll hand over to Niamh now to run our poll.
Great, thanks Helen. So similar to with CSRD, we are keen to understand whether or not your company is required to comply with CS3D. So we also have a second follow-up question for you. So if the answer to that is yes, we'd love to understand what is the most challenging aspect as you see it of preparing for compliance. So again, is it identifying those entities that are in scope? Maybe it's the complexity of the supply chain itself, engaging with stakeholders, internal and external. Perhaps it's ongoing monitoring or something else entirely. So similar to the last time, pop a note in the chat if we haven't included your challenge on that list of options. So again, thanks to everyone for lots of participation. We're heading towards the 50% mark, so we'll just do a short countdown again. Let's go 5, 4, 3, 2, 1, and we're just over 50% now. So lovely to see everyone getting involved, and we do have some interesting results coming your way. So I'm going to end the poll now, and let's share the results with everyone so you can get a sense of what everyone else is finding in terms of challenges.
Thanks, Niamh.
Okay.
So yeah, broadly sort of similar actually to CSRD. So about 40% saying you are in scope for CS-DDD, 29% saying no, and 29% saying not sure yet. And again, that may be because it's not your job within your business to know the answer to that, but I would say make sure that somebody in the business knows the answer to that question. And CS-DDD is a little bit more recent. It only became law this year in 2024 after a period of quite considerable political uncertainty as to whether it was actually going to come into force at all. So I think most of the clients we're speaking to are a little bit further behind in terms of their preparation for CS-DDD. And then looking at the most challenging aspect of that, so the highest at 40% is supply chain complexity, and I know that is you know, a huge topic for most of the companies we speak to, who maybe have got good visibility on their tier 1 suppliers, but not much further beyond that, and are really concerned about how to get this data in the first place. Stakeholder engagement, again, complex. This is, you know, businesses really vary on this as to the extent to which they are currently doing diligence on their supply chains, to which they really sort of understand their supply chains. Some consumer-facing businesses may have been doing this for a while already. Others, this may be really quite new. And then identifying which entities are in scope, again, that can be complex. And then the ongoing monitoring as well. So thank you all for participating. It's really useful to see the feedback on which aspects you're finding most challenging. And we will move on now just to a discussion really around CS-DDD. And Katie, might I bring you in first on the stakeholder engagement point? And that was certainly something that came up in the poll response, that's something that people are finding quite challenging. What does CS-DDD really require on stakeholder engagement?
So I think, like as we touched upon earlier, I guess there's internal and external stakeholders, and it requires to not work in silos, I think, to put it kind of plainly. This isn't, as we've said earlier, it isn't one, it's not something that one person can deal with, and it requires buy-in and commitment, I think, from each department. And certainly from when we've been speaking to clients, you know, it's not, we're not just speaking to legal, we're speaking to kind of the HR functions or the finance functions, the ESG functions, because as I say, there's it's not possible really for one person to obtain all of the necessary information. So I think there is just a real need to make sure that you are engaging early with everybody that needs to be involved in those conversations. And I guess as well, that also relies, if we're talking about external stakeholders as well, that relies on having good relationships with your supply chain and being able to start those conversations early.
Yes, and I think that's something that we've heard from clients, isn't it? That, you know, there may be aspects of the supply chain diligence that are public facing. You know, you might have a supply chain code of conduct or something like that that's or a supplier code of conduct that you require suppliers to sign up to, and that might be a public document. But any diligence that you're doing on your suppliers, the results of any diligence, how you're risk assessing your suppliers, those that you're sort of maybe, if you're doing a red, amber, green assessment, the ones that you might consider to be highest risk from, you know, any number of considerations, could be geopolitical, could be human rights, could be other things. You know, it's very unlikely that you would make that data public currently. That would be data that's typically used internally. So anything that's going to require you to actually make that data public, you know, makes it a very, very different discussion internally. Julia, I wonder if I might just bring you in on CS-DDD. I know that in Germany you already have the due diligence requirements at a local law level as well. So what's the feeling on this for German companies?
They don't like it, to say the very least. No, you can clearly see that in the current discussions in Germany. There was a proposal, for example, to delay the entry into force of the German Supply Chain Due Diligence Act, because the additional requirements that we have under EU CS-DDD, it's just too much, and you can clearly see that. You can see that in recent election results. You can see that in the results of the European elections. You can even see that in the results of state elections that we recently held in Germany. The Green Party, who was closely associated with all these requirements, be that correct or incorrect, it's, I think, probably open to discussion. Nevertheless, it's just a general feeling that it is simply too much for industry to cope with. So we can already see all these requirements. We can already see that, for example, if we look at the what is it, the regulation, EU regulation on products that must be free of, I think it's slavery. And one of the very first statements in that regulation is this regulation doesn't put additional obligations on anyone that are not existing in EU law. So that's, you know, that's like the very start of that new regulation. So you can clearly see what the overall feeling and the overall approach is. This is clearly, companies clearly feel overwhelmed, and they feel this is just too much. It's just too much to cope with. And also, I mean, we're talking also about the liability risks. So you have civil liability risks, you have enforcement liability. In addition, what we have in Germany, we have very highly developed anti-competitive rules. So any statements that are wrong and that may have a connection to the market, to selling products, can be attacked by competitors and can be used for cease and desist letters and even to take suits into court. So this is all something that puts an enormous amount of pressure on companies, and that way where you can see a very, very clear, let's say, disillusionment with all the with all the environmental policies that have taken place here over the last 3 to 4 years.
Thanks, Julia. And if we just move on to a couple of the bullet points around the civil liability and the risks of non-compliance. Katie, are you able to just talk a little bit about what that might mean in practice for companies?
Sure. So interestingly, with the CSDDD, the directive does actually require that member states ensure that companies can be held liable for damages caused for non-compliance. So if a company intentionally or negligently fails to comply with specifically Article 10 and 11 obligations, so those are the requirements to prevent and mitigate impacts or to minimise those impacts, then there are provisions for them to be liable in civil damages. And the other point I would make about that is there's also provision for member states to determine the conditions where human rights institutions can bring collective redress for individuals on behalf of victims who claim to have been a victim of non-compliance under, or impacted by non-compliance under CSDDD. So I think that's an interesting point, because it does mean that we could potentially start to see claims by NGOs, environmental NGOs, on behalf of individuals. So it'll be interesting to see how that develops. And then in terms of non-compliance, so I think I did see a question pop up in the chat in relation, maybe it was to do with CSRD, but I think in terms of non-compliance, there are some kind of key issues, and the two that I would raise is, I suppose, the main one, which is the large financial penalties. So the maximum penalty right now is looking like, I think it's 5% of the company's net worldwide turnover in the previous financial year to the year that you're supposed to be complying with the obligations. And so if we're dealing with, for example, one of the largest companies under the directive, so one that has to require comply with the obligations by 2027, their financial thresholds are pretty large. So you could see that a fine of 5% of that turnover could potentially be huge. I think I said there was two. I actually think there's three important elements. The second one is that I guess just the naming and shaming of companies. Nobody really wants to be the corporation that is found to not be complying and has their name plastered all over the media, particularly if you're a large multi-jurisdictional company. I think there are kind of some brand and reputation is probably a key risk of non-compliance or negative impact on brand and reputation. And then finally, the third one that I think is worth noting is that we may start to see compliance with CSDDD being a contractual requirement if you are tendering for public contracts. So where you don't comply and you don't meet your obligations, you could technically be in breach of contract. So I think these are just things to keep a watch on, but certainly something to be aware of.
Yeah, it really changes the risk profile, doesn't it, when you start talking about those turnover-linked fines, potential class actions, and we know that there are litigation funding boutiques which are particularly looking for those types of large group actions to bring as well. So there will be people who are willing to sort of bring together those claims. I see we've had a couple of questions on EUDR. I mean, I think at a brief level, Amanda, basically it's the requirements are not applying to kind of the downstream users of those products. It is for the people putting them on the market. And in terms of whether you're, whether you'd come within the scope of putting the product on the market as an operator or a trader, we can maybe pick up separately with you on what that might mean in practice, and also on proving that a product is deforestation free. That is quite a complicated sort of question, but again, maybe we can pick up separately with you on that, because I'm conscious of time, that we're just over the hour and I do want to close us out on time. Thank you so much for your participation today. It's been really great to hear. Very many thanks as well to the panel for sparing your time. And for those of you to attending, we have got another one coming up, another webinar on the 7th of November on the transition to net zero. And please feel free to reach out to any of the speakers directly if you'd like to have a chat about any of the topics covered today, or through the ESG programme email address below, which will direct to us as well. Thank you so much, and we'll close out now. Bye-bye.